Hello everyone and welcome. My name is Kavita Narayan. I'm with the Office of the County Counsel, and I'm here to give you an overview of the conflict of interest laws and rules that now apply to you as county employees. The goals of today's training are not to cover every word that you'll see in the slide presentation you have, because it's a lot of material to get through in half an hour. Instead, it's to give you those materials as resources, but use the time we have together today to provide an overview, give you an appreciation and basic understanding of the conflicts rules that apply to public employees, to help you identify the kinds of personal, financial, and non-financial interests that could raise a conflict with your county work, to make sure that you understand how conflicts of interest can arise in the work that you'll be doing as county employees, and to know what to do to solve the problem if you think you may have a potential conflict. Since many of you are new county employees, we wanted to start the presentation with an overview of the broad range of services the County of Santa Clara provides. Some of these pertain to the health work that you all do, many others do not. And the goal of this slide is to give you a big picture overview to understand the many areas in which the county is involved, because each of these areas involve decision making by government officials, and every decision that's made by a government official presents a potential opportunity for a conflict. Again, the overview of the critical kinds of county decisions that we should be thinking about: soliciting and contracting for services by non-county providers, because of course in the government setting, most contracts need to be competitively solicited. The second would be making recommendations on goods or services the county should purchase or use. And the third key area is making local laws, meaning ordinances, and local policies. And I would also add establishing local programs to this point. Additionally, there are decisions made at the county level on licenses, permits, and certifications that can be granted to applicants. Making referrals to outside agencies, this is very relevant to the healthcare area, as well as making assessments of outside entities such as appraisals or inspections. All right, the big picture of the conflict of interest rules. The laws that we have in California are quite stringent, as you'll see in this presentation, and they're grounded in two basic principles. First, that government officials, and when I use the word officials throughout this presentation, you may be thinking of elected officials, the county executive, sort of high-level officials. Instead, what we mean by that term in the setting of conflicts is all employees. It applies to me, it applies to all of you. So when you hear me say officials, I mean you. Again, so the first basic principle here is that government officials are expected to act primarily for the benefit of the public, and that any personal financial interest should not be entering into the governmental decision-making process. And the general rule is that a public official should not participate in an official county decision if he or she has a disqualifying financial interest in that decision. And we're going to go over what that means. The conflicts rules are found in the California Constitution, as well as California law, the County Ordinance Code, and county policy. Now, having a conflict of interest does not necessarily mean that an employee has done anything wrong. It simply means that the person has a financial interest or some other kind of personal interest that prevents him or her from taking part in certain county work. When the problem occurs is if the person is involved in making recommendations or decisions at the county that they should not be performing due to having a conflict of interest. And a key note here for all of you coming newly into county employment is that activities that may be allowed in the private sector, such as having a vendor pay for lunches, meals, provide other benefits, those are not allowed in government service. The conflicts laws have both disclosure and disqualification requirements. And I'm going to start with disclosure because this is a key subject area that many of you will be facing within the next month or so. Employees who are in designated positions, meaning positions that have been deemed by the county to involve the exercise of discretion and decision-making power, are required to disclose all personal financial interests on what's called the Form 700. I have to do one, and many of you probably do as well. This is a public document that is intended to sunshine financial interests, so that, let's say a member of the Board of Supervisors owns a significant amount of stock in a company. it's important in California that the public be aware of that financial interest and can keep an eye on government business to make sure that person isn't making decisions that could impact their private interest rather than benefit the county. So in addition to that transparency point that I've just talked about, the goal of these forms is also to alert the county to the types of financial interests all of our employees have so that managers can keep an eye on and make sure that they're not assigning their employees to do work that creates a conflict. This is a form that each of us has an independent responsibility to complete fully and accurately. It's submitted under penalty of perjury. And those of you who are going to be subject to this disclosure requirement will be individually notified by what's called the filing official. The county health and hospital system has a designated person who's in charge of this process, and they will be getting in touch with you if they haven't already. Once you have a financial interest and you disclose it on your Form 700, let's say your spouse works and you disclose their income on your Form 700, that doesn't necessarily disqualify you from working at the county. On the other side of that coin, if you have a financial interest that you disclose, that doesn't erase the conflict. All that means is that the conflict or the potential conflict is now publicly known on the Form 700. When disqualification is required is when a county employee is faced with working on a specific county decision that could then have an effect on the employee's personal financial interest. And disqualification may also be required for non-financial reasons. I know that this is a bit abstract, so we are going to discuss specific examples to help flesh that out. The kinds of financial interests that California law says we need to be reporting and looking at for conflicts reasons include income, with the exception of income received from a government agency. So this means any income received by you or by your spouse because you have a community property interest in your spouse's income, other than that which is deemed exempt. Loans. Any gifts, meaning not just cash, but any items of value such as payment or reimbursement for travel, meals, other items of value. Travel is its own category, any travel that's not paid for by the county. As well as investments, having things like stocks or bonds or other investments in a company where you may receive dividends, that's reportable. It is as well if your spouse or a business entity that you have a share in holds investments. Real property interests for any real property that's located in the county or adjacent to the county, meaning within 2 miles of the border of the county. Any business position, meaning if you or your spouse hold a managerial level position in a non-county business, and then just your personal finances. So that's what your potential interests are. When can conflicts come up between your personal interests and your county service? Some of the key questions, and this is not an exhaustive list, but just a list intended to get you thinking, to ask yourself are, am I involved in any stage of contracting for the county, from research to planning to evaluation to selection and negotiation to monitoring the contract once it's signed to providing payment? Do you help make decisions about outside entities, ruling on license applications, permit applications, that kind of thing? Are you making recommendations to executives, whether at the hospital or at the county as a whole, or to the Board of Supervisors on county policies or county programs? Do you have any hiring authority or make recommendations about staffing and assignments? Are you involved in any stage of contracting or supervising work to be done by your former private sector employer, if that employer contracts with the county? One of the 2 key state laws that governs the conflict of interest rules in California is Government Code Section 1090. This law is specific to county contracts, meaning everything from what you might typically envision as a contract to amendments, renewals, extensions, grants, purchase orders made under a master contract, which is very relevant in the healthcare setting. There are many, many contracts that have a master agreement and then purchase orders or work orders issue from that. And the basic rule here is that a county employee who's interested in the outside party that's contracting with the county cannot then recommend that the county contract or not contract with that outside party in which the person is also interested. Now, what does it mean to participate in making a contract? What's the prohibited activity here? It's not just signing on the dotted line. There's a lot more that is deemed to be participating in a contract. Everything from preliminary discussions. Hey, I think we have a need to procure a particular type of medical device to meet patient needs in our county. Planning, how are we going to get the contract done? How many vendors do we want to invite to bid? Creating plans or specifications, overseeing a solicitation, evaluating bidders, engaging in negotiations with potential contractors, and then finalizing the agreement. All of those would be the kinds of things that are prohibited. And under Section 1090, it's a very strict rule. It doesn't matter if the contract is fair or more advantageous to the public agency. Let's say, for example, you own, in addition to being a county employee, a side business that's a food vendor. And you could offer a discount to the county if they decide to buy meals from your company. It doesn't matter if those meals are cheaper than what the county could get from another vendor. By influencing the county to enter into a contract with your own company and thus provide you with private profit, that would be prohibited. It also doesn't matter if there's any actual fraud or dishonesty. It's what we call a strict liability rule, that if you have a conflict, then there's a violation, whether it was intended to be fraudulent or not. And it doesn't matter if the official acted in good faith or on the advice of counsel. The official also doesn't need to intend to violate the law. Now, a quintessential example, this is similar to the food vendor example that I just alluded to. Peter's spouse has founded a healthcare technology company, so Peter has a community property interest in that company's profits. Peter participates in county staff decisions to develop a contract solicitation for healthcare technology services for which his spouse's company may submit a proposal. Now, because Peter has a community property interest in the health of his spouse's business and his spouse's income, if he recommends or offers input to the county that they should potentially contract with that company, then he's on both sides of the transaction. But what the laws require is that we only be on the county side. And if you're present on the other side, if you have an interest with the outside company, you should not be involved in those conversations. A less obvious example, and this is to make us all aware of situations in which we may be part of a string of transactions as opposed to something as direct as the Peter example. Sue is the landlord and her tenant is a medical device manufacturer, owns a medical device company. Sue served on a county committee dealing with contracts, and she influenced the committee to recommend that the county contract with that medical device company. This is a Section 1090 violation, and why is that? Because if Sue's tenant, who owns the medical device company, wins a county contract, that may be a valuable contract. And if the tenant has more income, they're more likely to be able to pay the rent to Sue. So even though that's more attenuated, there's more steps there, that would still be considered a violation. The consequences for violations of Section 1090, again, it's a serious statute. The violator, I'm going to the second bullet first, the violator can face a risk of criminal conviction of a felony, including imprisonment and criminal fines, as well as a permanent ban on holding public office in California. In addition, the contract is considered void from its inception, which means it's as if the contract was never made. And there is a real example in Southern California of a waste management company that provided services to I can't recall if it was a city or a county, but for a number of years had quite a valuable waste management contract. That contract was found to violate Section 1090, and the courts required not only that the contract be voided, but that all of the money paid to the vendor be returned, even though they had already provided the services. So that's obviously a serious consequence for the vendor there, but it really isn't good optics for the city or county either. One additional point on Section 1090 is that as of several years ago, the California legislature added aider and abetter liability to Section 1090. So meaning if you're not engaging in the violation yourself, but you're assisting or encouraging someone else to do so, whether that's your supervisor, this could also apply to actions that we do as counsel, providing advice. So it's important to be aware that even if you're not the decision maker, if you facilitate a supervisor's actions, that could count as well. So, okay, I've just scared you with all of the rules around 1090. How do you avoid Section 1090 conflicts? Generally, public officials, other than members of the Board of Supervisors or other of that kind of elected official, can avoid violations by disqualifying yourself from any involvement in the contracting process. So Peter's spouse has that medical device company or healthcare technology company. If the county is wanting to think about contracting with that technology company, Peter should be walled off. He shouldn't be participating in any meetings about it, looking at bidders on that contract. At no time should he be involved in working on a contract with his spouse's company. And the county can still proceed as long as Peter is not involved. And this is why it's important for all employees to immediately notify their supervisor as well as the compliance office, even if you suspect you have a conflict, if you're not sure. Because we can't fix conflicts after the fact, but if we know about them in advance, almost always we can find a way to make it work such that the county can still engage in the project or the contract without creating a conflict. Shifting gears to a county ordinance that covers some of the same subject matter. In many areas of county business, especially in the health and hospital system, there are people who are hired into the county from private sector employers, and they may be private sector employers the county also contracts with. So under the County Ordinance Code, section 825-601, no county employee can negotiate or supervise a contract like that between the county and the employee's former private sector employer. They also cannot supervise work to be performed by the private sector employer within 1 year. And the reason is that for a year after leaving an employer, we consider that there is an ongoing loyalty and possibly even ongoing pay as things are being closed out from a former employer. So we set a 1 year period of when you've come from a private sector employer to the county, until a year has elapsed, you can't be involved in any work that goes on between the county and that employer. And here's an example of that, where the county has contracted with an outside firm to work on implementing a project. The county hires one of the individuals from the firm as a county project manager who's now working for the county. The county department wants to assign that project manager, program manager, to oversee the project that's being worked on by their former firm, but that's not permitted. Okay, shifting to the second big state law that we're going to talk about, the Political Reform Act. Under state law, the Political Reform Act, public officials are disqualified not only from working on contracts where they have a financial conflict of interest, but also from being involved in making any kind of official decision in which they have a financial interest. This could be things like developing and working on county ordinances or policies, developing programs, making any other kinds of decisions that are not contracts. Those are also covered by the Political Reform Act. Again, actual bias is not necessary to be disqualified. It's not necessary to show that an official's actual assets or amount of income will be affected by a decision in order to have them be disqualified. And that's because, as was mentioned in an earlier slide, the laws are intended to prevent not only actual conflicts, but also the appearance or likelihood of conflict. When disqualification is required, the official must step aside from the entire process leading up to the governmental decision, just as I mentioned in the contract context. It's not just signing on the dotted line, it's not just the board stamp of approval that could implicate a conflict. It's all of the recommendations and planning up to that point. So how do you avoid Political Reform Act conflicts? In a similar way as we discussed with Section 1090, don't participate in any aspect of the decision-making process, including everything from being present at meetings where your colleagues are talking about a program, to offering recommendations to colleagues or your supervisor. Don't knowingly obtain or review any non-public information about the decision. And again, immediately notify your supervisor as well as the compliance office at the health and hospital system if you suspect that you may have a conflict. State law and county policy also have a number of prohibitions on accepting gifts. I will not be able in the time we have to go through and detail all of the state law requirements around accepting gifts. We'll touch on them briefly, and I'm also going to touch on a couple of really critical county policies that you need to be aware of, because this is actually an area where county policy is stricter than what state law requires. The first is in the Board of Supervisors Policy Manual, Policy 5.2.5.2H, says that county employees who are involved in the making of a contract, including monitoring the contract, are prohibited from accepting gifts from the contractor under that contract. It's the highlighted text. Now, what does that mean? So it means that any county employee who's working on a county contract, that means, again, everything from planning, evaluating bidders to a solicitation, as it says in the policy, monitoring the contract, cannot accept any gifts, any items of value from that contractor as long as the contract is open and pending. Under that contract means as long as the contract is open and pending. So this is just an absolute ban, against a bit stricter than state law. Even stricter than that, hospital policy completely prohibits receiving any gifts from county vendors, whether you as an individual are working on that contract or not. So the general county policy is if you're working on a contract, including as a monitor, no gifts from the vendor. Hospital policy is no gifts from any county vendor, period. And a note on this, this is the policy that currently applies to Santa Clara Valley Medical Center. This policy does not currently apply to O'Connor Hospital in St. Louis, but there is an intention to develop specific policies for those hospitals that will more than likely be consistent with the existing policy for Valley Medical Center. And this is something that maybe have been very, very common in the private sector when vendors come on site to provide trainings. They may offer a lunch or a dinner with the training, or they may take you out to a meal. That is absolutely prohibited under county policy. And this is an area that results in frequent questions that either the compliance office or the office of the county council is happy to help you with if you have doubts about this. Switching gears again to the honoraria ban. Many people have heard of the concept of an honorarium. It's typically thought of as a speaking fee. So a fee or a payment that's given to you in consideration for giving a speech, serving on a panel, or publishing an article. Every county employee who's required to file a Form 700 may not accept any honorarium from any source they're required to report on their Form 700. So if you are reporting an outside source of income, an outside source of gifts, anything like that on your Form 700, and then that person or company offers you a speaking fee, it's just flatly prohibited under state law to take that. And there are some exceptions that apply primarily to physicians, so if that comes up for you in your work, please do consult us. One of the final buckets we're going to talk about today is non-financial conflicts of interest. Everything I've talked about so far has been specific to financial conflicts, but there are also a couple of principles in California relating to non-financial issues. First, there's the common law. This is a body of law that's been developed through court decisions. The basic idea is that a common law conflict can be a financial or non-financial conflict that can impair a public official's exercise of judgment for the public interest. I'll give you some examples on the next slides, but just to go through some more overview. County policy embodies that general principle in our anti-nepotism provision, which prohibits department heads specifically from appointing close family members to positions in their department. And that's kind of an obvious type of conflict, even if you don't have a financial interest anymore in an adult child. There is a clear appearance of conflict problem if you're appointing your adult son or adult daughter to a position in your department. So the county charter prohibits that. Generally, the kinds of questions to ask yourself when you're identifying non-financial conflicts: do you have a personal or family relationship with someone involved in a county transaction or another type of close personal interest in the county decision, such that either maybe you feel like you can't be impartial, you can't be loyal only to the county and the public, or it may look that way, even if you do feel you can. And this is an area, because the law is a bit broad, that it's advisable to consult county council if you have doubts. Here's an example of how to avoid a conflict or appearance of conflict for a non-financial issue. This is a real-life example. If an employee is a member of a church congregation, not on the leadership, not the pastor, no financial interest in the church, but just a member of the congregation, and that employee's department issues a request for proposals for faith-based service organizations, it would not be a good idea to have that employee be involved in evaluating the proposals where her church has been one of the bidders, simply because by virtue of being a member of that congregation, she may have a personal allegiance or a personal interest in seeing that church do well and be able to provide services to the community. So what we would advise in that scenario is that employee should be walled off. Another example that's not on the slide may be if my cousin owns an engineering firm and I'm making recommendations to my boss or to the board, or I'm asked to review for form and legality as an attorney for the county, a contract between the county and my cousin's engineering firm. Well, I don't have any financial tie to my cousin. We're both adults. There's no shared financial interest, but because of the personal bias that's inherent in that situation, that would not be a good idea either. Outside employment and incompatible activities. This is an area where both state law and county policy require that employees not engage in any outside activities, whether paid or unpaid, that are inconsistent with the requirements of county employment. There's a duty to self-report, and there's a county outside employment and incompatible activities form that is provided for this. It's a standard form throughout the county that is filled out annually, and if you take on any new outside activity and given to your supervisor. Now, the kinds of outside activities contemplated here are not just if you own a consulting firm or have a paid business on the side, but also if you are a member of your children's school board, if you're joining a nonprofit board, any kind of outside activity that involves a significant amount of time. Not if you are attending your child's soccer game on the weekends, but there's no sort of official position there. But if it's anything more than that, good idea just to ask. And sometimes there are questions about whether unpaid activities that may not be incompatible still need to be reported. Our response generally is if it may include any use of county time or just a significant investment of time in general, it's probably best just to ask. Conflict of interest rules when leaving office. You may have heard these referred to as revolving door prohibitions. So just as I said probably a dozen slides ago that when a person comes to the county from a private sector employer, they're deemed to have an ongoing allegiance or interest in that employer for a period of a year. In the same way, if you have a prospective employer, you're planning to leave the county, you have a job offer from Apple, then you're considered to have an interest in your prospective employer because you want them to do well so that your offer stands and isn't rescinded and you're going to a good company. So the Political Reform Act prohibits local officials, including all of us, from participating in any official decisions that relate to a prospective employer. The county's revolving door ordinances at a high level, because these are pretty technical rules, prohibit county employees, once you have left the county, from lobbying the county on any matter that you either directly worked on or supervised once you have left county employment. So if it's something you personally worked on, it's a lifetime ban. If it's something that you just supervised, it's a period of 1 year. The reason being that you may have access to inside information and it's inadvisable for you to be lobbying the county on those matters once you've left county employment. The consequences of violating the conflict of interest laws, I've already mentioned the criminal conviction that can result for 1090 violations. There's also a possibility of discipline in your employment up to and including termination. So that would include everything from, a counseling, a letter in your file, suspension, all the way up through termination. Fines and criminal charges we've talked about. And then for the county, possible invalidation of that decision. Key takeaways here, very last slide. Every public official, again meaning not just high-level officials, but all of us as employees, should be aware that conflict of interest rules and prohibitions exist, should be aware of your own personal financial interests, as well as your non-financial interests that could impair your exercise of judgment for the benefit of the county or could create an appearance of impropriety. And if you think you might have a conflict, again, ask early, ask often, check with the Health and Hospital System Compliance Office, go to your supervisor. They can help determine whether any items need to be elevated to county council to get a legal opinion. You're not expected to know the details of every conflict of interest law, but this presentation is intended to help you work to just identify what could be a potential concern so that you can bring it to us. And with that, welcome to the County of Santa Clara Health System.